Dinesh Jotwani. I run a law firm, Jotwani Associates. I have been in-house also to big several multinational companies, including Microsoft, NCR Corporation. So I used to handle IPR, intellectual property rights for these companies. Full-time now, we have a law firm, around 55 associates working with me, different field. Of course, IPR is like 80% of my work is intellectual property rights, and patents form a very, very important part of what we do at Jotwani Associates. We do also do a lot of litigation in the court. So when the matter, including patent litigation that is going on in India. So a lot of the things that we talk about today, they do get reflected in the courts in different manners. Of course, whether it is valuation of patents that Professor Hines talked about, or the taxation part of it that we'll be talking about today. There is a little overlap of what Sir Hines just talked about, valuation of intellectual property rights. I have the same slides, actually some of the slides are common, but yeah, I'll just re-emphasize more from India perspective, okay, and particularly from some of my experience in litigation. Though let me warn you in advance, some of the slides, which I'll skip of course, but are absolutely common to what has already been very beautifully explained by Professor Hines. But we can have it as an interactive session, no problem.
Thank you very much.
Sure, okay.
That is what I was asking.
Alright, so let's move on to my slide 1, which is, so we'll be talking about IPR valuation, IPR taxes. Now again, the taxes part of it is extremely complicated. I'll be mostly talking about the impact of taxes in India. We'll be talking about royalty, how do we define, and this is more to do with Indian Income Tax Act 1961, and then the transfer pricing issues that are going on, especially in the IPR area. In fact, yesterday we filed one appeal at IIT regarding a transfer pricing issue only. IIT is the Income Tax Appellate Tribunal where most of the tax problems goes, but this is more to do with intellectual property rights, valuation, and ultimately it comes to valuation, how much the transfer, how much the income tax officer thinks is the transfer price, and how much the company, the assessee actually gives it. So we'll be talking about some of these things. Let's go to IPR valuation part of it first, and I'll skip a lot of the slides because we've already talked about it. Let's go to the next slide. All right, and now I can't see, but yes, the figures here tell you about the value of intangible assets versus tangible assets in an organization. So as we move forward in technology, we see that most of and this is data from Fortune 100 companies, which actually shows that more than 65 to 70% of the assets are in the intangible form. And when we say in the intangible form, it actually means that a substantial part of it is intellectual property rights. We will talk about the formal IPRs and informal IPRs in the next slide, but at this moment we should understand where the organizations are going right now with blockchain and artificial intelligence taking over a lot of the human things that are there. So the value of intangible assets in all these organizations are going up. No value of furniture, no value of assets, real assets. You can work from home. These organizations are actually, if you see their share price at the stock exchange, it's mostly based on, and whenever there is some news on cryptocurrencies or somebody introducing a new product, artificial intelligence, that's where the valuation of the share goes up. So again, we see that the Fortune 100 companies moving more towards technology oriented and more towards increasing their brain power, as they say, and that's how they are capturing the market. So that's comparison between tangible and intangible assets in an organization. So next slide, let's go to the next slide. Okay, as I was talking about, intangible assets are also of two types. Today we are talking mostly about IPR, which is formally protected by law. Patents, trademark, copyright, designs. The trade secret again is a kind of it's in India we will say it is not formally protected, but outside India, many jurisdictions, and I don't know about Germany, but trade secrets are formally protected. You could actually file an application and protect your trade secret, but that's not the case in India. It's just through contracts.
One remark: employee retention law. The employer has the choice in Germany to treat something which the employee gives to them as a trade secret or to patent it. But if he treats it as a paid trade secret, he has to pay the remuneration as if it would be patented. Otherwise, what?
Yeah, that's very interesting for me to know. That's how it happens in Germany. But many organizations in India don't. There's no incentive for a trade secret. But sometimes trade secrets are much more valuable than patents. Patent would expire after 20 years, right? And trade secret. Look at Coke. Look at McDonald's. Over the centuries, they have protected KFC. The way they make their chicken. No, we don't know. All the children find it very tasty. So the power of trade secrets is extremely important, which is not formally in the second section of my slides, which is actually not formally protected in India. But if you go outside India, the trade secrets would be protected. Other examples of not formally protected are your know-how, your talents, your skills, the workforce, customers list and distribution list. I just want to emphasize on the point of workforce. So today we see extreme importance of India in the global market. Every company wants to be here. All Fortune 500 companies have offices here in India somewhere. Okay? And I give credit for our workforce in that. I mean, people would say population has, if our population is educated and is able to serve the global market, India is the best place. We have young workforce right now. They understand with the advent of artificial intelligence, this young force will actually come and using AI also is a skill which our workforce can do. So this kind of intangible assets that India has is amazing. We are at very interesting point, and I'm very excited about the way the things are going on. Okay, move on to next slide. Why do we value an IPR or why do we value a patent? Is many reasons for that, and I would say the reason is, of course, as I said, it gets reflected ultimately in the valuation of a company. But if there is some transaction happening, like mentioned in the slide, if it is an outright sale, if it is a license, if big companies want to license their product, especially as I said, I was in Microsoft. So today also most of my clients are in that background in the software. So we handle a lot of issues in licensing, and sometimes the matter goes to the court also about licensing. So if you want to license a piece of software, of course you should know the value, what the market value is. Another reason, very important reasons for valuation is mergers and acquisitions that are taking place. Loans, we have seen trademark being pledged with the bank and companies getting loan based on that. Litigation and arbitration disputes, this is what we do almost daily, where as I said, we represent some big software companies, and ultimately if their license gets violated, if there is a piracy happening, this is where we have to approach the court and seek damages on the basis of piracy happening. And piracy is nothing but a violation of Copyright Act in India. In terms of donation, in terms of transfer pricing, and we'll talk about transfer pricing, we again need valuation of IPRs. In case of bankruptcy and reorganization, NCLT, you talk about India has new forums, NCLT and NCLAT, which is where if a company is reorganizing or there's a bankruptcy proceedings going on, and we know the example of many big companies where IPR became very important during the dilution. Kingfisher example is there. So the brand name itself was so much valuable at that particular time. So if the matter goes to NCLT, the valuation of a brand, who will buy the brand? Maybe the brand during pendency of a proceeding, the tribunal may decide, okay, the IPR piece will go to this company, whereas the other assets will go to another company in the liquidation proceedings that go on. So that's where the importance of IPR comes in. That's where the importance of IPR professionals also come to give advice to the court, because the court may not have that expertise with them. The judges may not have that expertise of how they value intellectual property rights. So this is another kind of an area where which attracts IPR professionals. Financial statements and reporting, very important part of it. As I said, the value of the shares today is based on mostly intangible assets that a company has. So how do you value that? Tomorrow Infosys goes to the Bombay Stock Exchange and says, this is my valuation. It's workforce, right? How do they calculate? How do they value their intellectual property rights? So these are some of the examples where you as IPR professionals, whether patents or trademarks or copyrights, you would face this dilemma of giving calculations to the management, to the courts, to the regulators, to the judges, that this is how I arrive at my valuation of IPRs. So next slide, please.
Sir, can I ask one question?
Sure.
When we talk of valuation of intangibles, then there have been in past many cases, I will not quote the exact case, but where it has been considered as a scam or something, and there was lot of thing that so much of notional value and there has been loss, and later on when the same thing was transferred, the actual cost the market could bear was not even half of that. So in that case, when the people get what I'll say sentence from the courts and all, so why do you think that when we talk of intangibles and notional values and things like that, and when in practical in reality it bears different value, then how to address that gap and the people who suffer because of that? How to address these are the issues?
I understood actually where you're coming from, and I agree with you. There are a lot of disputes on the valuation part. In fact, I was representing a client at NCLT, and there were several buyers of that IPR, and the judge said, look, what is happening? Can they actually do it? Even he didn't know. Can they value different people value differently, and there is an acquisition happening on that. So it was his, judge's remark, it's a scam. It was like last month I was appearing, and he said, look, it looks like a scam to me. And I told him, Milord, I agree with you, because I would say even the subprime crime, the subprime crisis in US, which actually was responsible, was because of this notional value of things that are happening. One bank will acquire at that time they were real estate, not the IPR, but again there was a confusion in the market and the banks about the actual value of things that are going on. So I mean, given that practically you are right that these things happen, but we still, as professionals, I think and Professor Hines has already talked about all of these approaches to valuation of IPRs. And our role will be to mitigate all these, I would say, confusion in the market about the value of IPRs.
Actually, that is exactly my question. How to mitigate the gap between the notional value which we calculate theoretically and the actual value it translates later on.
Right. I think your earlier question, I think you posed that to Professor Hines, which is the best way to do it.
Yeah,
and if we do it in the best way, perhaps that will remove the confusion in the market. If we have a common analogy of saying, okay, this is how you value an intellectual property rights. Let's imagine, and I will again go. I was listening to him very carefully, and he was relating the intellectual property rights to a real estate, say a real house. So if you think in those perspectives, and perhaps that's where perhaps the confusion will go, or you will understand, a house which is there, I may value it in a different manner, and you may value it in a different manner. I like properties on the top floor, and you don't. You like on the ground floor. Especially Delhi, in North India, I see people liking a property which is on the ground floor. It's much more valuable. Whereas you go to Mumbai and Pune, where I used to live early, people would value more the top floor. So it is. You can't say it is a confusion in the market. If you in the real estate also this happens. So let's not call it a confusion, but let's call it. Let's give it a reason, and perhaps these are the reasons which will mitigate that confusion in case of intellectual property rights. So let's go to the next slide, which is market-based approach, and we already talked about it. In a real estate scenario, this is what Professor Hines is talking. So there are going to be common slides, but I'll skip.
Sir, when we take this approach,
yeah, our topic is same.
sir, if you permit, I'd like to ask one question. Well, if we follow this method, then for a new technology, which is patented also, it's very hard to find a comparable comparisons, and those comparisons generally data is not available,
Right.
even if it exists.
Right.
So how to go about it?
Right. So maybe we don't have this approach then, market-based approach, because in case of every patent by definition means something new, right? If it is something new technology, how do you give a valuation to it? For example, some kind of an application on AI. By the way, yesterday I was trying to use AI in my slides. I didn't, but slowly I will learn and use AI. But that apart, how do you handle?
Because there are no comparisons
There
available.
is no comparison to make. Okay, so perhaps we dump this approach. Okay, but in case of a real estate, if I have to sell my house, as you were saying, what do? I see, okay, my neighbor sold it for such and such price. That's the market-based approach. But here, in case of patents and copyrights and trade secrets, how do you value it? Okay, so maybe we go to the next one. Cost-based approach, which is again Professor Hines was talking about the employee contribution and how much cost it actually incurred. But that's not the way you should do it. I don't like this way. That I incur so much expenditure on employee, on the salaries, and in terms of his coming IPR, I give that the valuation and make a 20% say profits on it, and I just value it in this manner. No, I mean, if I buy a house, I won't say I bought it in 20 years back, and so let me put some profit on that and sell that house. That's not the way to do it. At least I don't like it. But there are people who would say, okay, I acquired this for such and such money, and now I have over the years, if I say 10% increase per year, it should be this much. This is what the cost-based approach is. Many people do that. It can happen in real estate, it can happen in IPR situation also. Okay, next slide.
Sir, in cost-based approach,
Yeah.
perhaps it is more close to tangible and easier because we know the cost of the project. But one thing which was covered in the earlier lecture, I don't know how it will be applicable in Indian context. Do we pay something to employees in Indian private companies and all?
Yeah, I
Because
was
in
part of,
government, at least it is not.
yeah, unfortunately, most of the Indian companies don't give, but I was part of Semantic, so I used to Semantic and Microsoft, and I used to run the patent program there. So our headquarters, both of the headquarters are in California, in Mountain View actually. So they had a policy of awarding their employees, and awards used to be extremely substantial. I'm talking like 15 years back when I used to have that, and they would range from $300 to $400 per invention if it gets patented.
So it's again a multinational which headquarters are not in India. Indian companies I'm talking.
So Indian company, there is a legislation pending. Dr. Pinaki would perhaps be able to answer that.
Yeah,
Yeah, thank you everyone. So those who don't know me, that I worked in GE, Infosys, Reliance, KPMG, IPR professor. Okay, the question that you asked for that, why, which Indian companies are having, Infosys is having. When I was the head of Infosys, so we have a process there. We inbuilt the process, but it is a nominal. It is a $500. $500 for an Indian company is giving the for one, if there is one inventor, if there is a two inventor, 500 plus 500. If there is a three inventor, 1000 divided by 3. If there is a five inventors, 1000 divided by 5. Maximum is 500 per individuals. Why we have divided these 5, 6, 7? Because in Indian tendency is that when you are filing a patent, it is to please the boss. Right? Everyone used to be the boss name, next boss name, next boss name. So the employee, the inventor, who's supposed to be the real inventor, his name is not. So we divided that number of people. So what happened into that one? That bosses, ex-boss is knocked out in the process because the employee demanded more money. Then he contributed into that. So there is a process that we told that inventorship is not the authorship, but people have to abide by this process. So we have inbuilt that process in Indian company. In Reliance also there is a there. But unfortunately, as Dinesh was telling, we are advocating for from 2009 onwards that in Germany, in Japan, in Australia, there is a royalty sharing is there. In India, there is no royalty sharing of the patents. Okay? So we were still struggling. I myself have 26 patents in G, and I have only got 500 for those time. But those patents are now in the G machines. There's ultrasound, MRI, and all this. I am happy to tell that I have contributed that one. I have patents. That's all. So
Thank you, sir.
we are trying to best. Okay,
Sir, what is which is the bill pending? You're telling some bill is pending.
There is no bill pending. We are advocating for that one.
Which
bill is going on? This discussion.
Right, sir. Thank you, sir.
Thank you. Yeah. So good. I hope we are successful in. It's kind of a in US. I think they call it Bayh-Dole Act. In the Bayh-Dole Act, all the employees actually.
One bill which is similar to Bayh-Dole Act, which is pending in Rajya Sabha, I think.
Yeah, and there was. I think it got abandoned.
2008
Dr. Pinaki would update you on that. But at this point of time, there is nothing before the Parliament similar to a Bayh-Dole Act, which would incentivize an employee or an engineer who had contributed to the invention. So coming back to the valuation, this is again an economic-based approach, which is looking at the historic profits. It's like your house. You look at it, which locality it is. Is it a corner plot? Is it having a park? All those historic data that you do, and see the importance of IPRs and perhaps, and in fact, my colleague Babita was helping me out with one of the queries that came from Sri Lanka a week back, where the law firm there wanted to do a valuation, and they told us how you will do it, the valuation, and they had a similar patent in 3 different jurisdictions, and that patent actually went into a product which had like 50 other patents in it. So how would you value that, right? How would you value her piece of patent which would go into a product which already has 50 patents in it? Okay, so very complex way. In fact, giving a proposal to that or a price quotation for that was a difficult task for us. How would we value that piece of patent application? Next way is perhaps may answer income-based approach, which Sir Hines already explained in a very crisp manner. What we actually look at is projected cash flow. And this is what we actually proposed to the query that came last week, where my associate Babita was working. Projected cash flow, economic life, and discounted rate. This is what we talked about in NPV's slide already. So I'll not go into what actually it means, but yes, I can just relate it. When you go and take, everybody takes a loan here, right, from the bank. I suppose at my age we have to take. Next slide will show the same which was shown by Professor Hein. So what the bank do is they mortgage the property and they look at it, okay, they use the same, okay, 20 years loan I will give you, and this is what perhaps the cash flow is going to be for me, and this is what the final valuation, and I give 50% of that as a loan to you. So I'm not talking with respect to intellectual property rights, but this method, income-based approach of valuation of IPR. So if you have a patent with you, and there are 50 other patents in a product, perhaps I would look, okay, suppose that product is having $1 or $2 billion of market in India. I would say, okay, this patent will go into, it's going to be, maybe it's an AI plug that goes into this product. Okay, I have a patent on it. Maybe this product I'll give it a 5% value, and this is what the market share is, and over 20 years is going to be this much. Rate of interest, again, India has a lot of rate of interest, so maybe 10 to 12%. So this is what the value is going to be at today's price, and this is the method that I would recommend in calculating.
Sir, in the case of banks, the rate that is taken from the bank lending rate decided by the RBI, that then they say that above this.
But how do you value a piece of property being mortgaged? I know RBI gives you a formula for it. RBI don't invest too much, 80%. It can become a non-productive asset, NPA.
No, I'm not talking about that, sir. I was talking about the rate at which you take the land. If bank finances it, then the rate is based on the prime lending rate decided by the RBI. In this case, how to decide the rate? Because when you actually try to value and then you try to transfer it, the potential licensee may or may not agree to that.
It is always negotiable. Okay, if the transaction is taking place in US, or maybe you make it a LIBOR rate, which is international rate of interest when you do a transaction. If it is in US, it's going to be less rate of interest. It's in India, and it's bargain. I mean, I would say ultimately when you sell your house,
Yes.
it's between both of you. If I like the house, I like top floors, I will pay more for it.
So basically, this calculation will become a point to start
Right.
for negotiations.
Right.
That's
Absolutely. Ultimately, valuation of a property would, intellectual property also would be negotiation, and it is subjective also. Even if the matter goes to we'll look at some precedents and some international examples, and then give you the valuation. And on the basis of valuation, it calculates the damages to be given to the plaintiff. So there is a lot of debate that goes on. There is nothing fixed. Rate of interest in India would be at a higher rate of interest. If you go to US, it's much less. If you do an international labor rate, it's going to be different. So it depends on jurisdiction. All forms a part of valuation, forms a part of your negotiation ultimately, how you value your property. Okay?
So basically, I mean,
Yeah.
sorry. So basically, all it boils down to that these methods are used to reach at a starting point of the valuation.
Yes.
Right.
That's all.
Absolutely.
That's all.
Sir
That's
has
all.
said absolutely
And
correct.
then it depends upon the negotiating skills
Right.
of the licensor
Right.
or licensee.
Right.
Because
Absolutely.
I asked this question from a Procter and Gamble executive in Singapore.
Right.
I said, tell me, how many times really this works? He said, off the record, only 5%.
yeah, that's the kind of
Yes. Absolutely.
So, but it is a good, it can be used as
It's
a
as a
starting
starting
point.
as a
Yes,
starting
as starting
point.
point.
Absolutely. I agree.
May I add? Just
Yes,
think,
yes.
just think about the option trading and the future trading in the stock market.
Right.
Okay.
So
Right.
you are buying a future product, you are buying an option trading. The risk that here the risk is there. Okay. So think about that one. The valuation is only on that basis. So these are the starting approach. Then there is the option based trading that can be a future based trading. There can be the Black-Scholes method also can be used sometimes.
which
But
method, sir?
all are risky side. It is not sacrosanct that this house or this patent is that much value, and it never can come down. It can come down. The Kingfisher case.
Ah.
It can go up, when the business is good, it's going up.
So that is the advantage of having three top most experts in the house.
Sir, actually, the problem,
Money and Dr. Pinaki Ghosh.
Many-
That's the advantage. And
right,
he will be
we-
deliberating on the topic post tea session.
Right.
we have got an excellent panel today, that's why I'm able to pose these questions because answers, what happens that,
in a layman language, I always say valuation, it's like beauty lies in the eyes of the beholder. Yeah, at the end of the day, it's.
sir, the problem happens when you have to write it on file and then it becomes a fixed. And then you are not able to negotiate, like the circle rate of a house. So you cannot go much below the circle rate of house, then the income tax authorities will question you.
Yeah, sure.
Maybe just one remark. I remember of 5 people in Saudi Arabia, Saudi Authority for Intellectual Property, exactly. There is a serious consideration. I think many countries have tried this, maybe also India. Germany has given up, no way. That you have a neutral institution, for example, by a patent office, by some special board for valuing intellectual property, which is generally accepted. The Saudis wish to do it. The Saudi do it, and Aramco and many other institutions, King Abdulaziz, I don't know what. And then you have an authority. It is also not true yet whether this is the real value, but if it is generally accepted by people who create intellectual property and wish to buy it, then you have an objective measure at least. You don't have so complicated maybe negotiations, but it doesn't exist in other countries. I don't know of that.
Yeah.
It would be great if a country invests into that, to have such an institution.
We should
Saudis wish to do it now. Yeah.
That's a wonderful
Suggestion for the
Yeah.
Yes.
If we have an institution which, institutional
So
mechanisms,
no personal interest involved.
So may I add here, the International Valuation Foundation, IPR, has come out in at least 5 years back or 6 years back, the intangible valuation standards. And then after that, Indian Chartered Accountant Institute, CA Institute, and Cost Institute, both had published that what should be the valuation method and what is the standards of the valuation. But still, because it is a future.
That is the problem.
So that is the problem.
Same in Germany. You have many people with very good reputation, they get that value, the other one gets twice that value. But if there would be a government control, I don't know what, I think if you have such a small market for innovations as, for example, Saudi Arabia, KSA has at the moment, then it might be worth the attempt. And if you have somebody who is at the top and has not to ask the parliament all the time, with all due respect, maybe there's authorities, we have to accept this, you better do, otherwise you might have consequences. No? So,
Yeah.
Please.
So the example that you were mentioning about in real estate, we call it circle rate. Many Delhiites would know, of course, what circle rate is. It's like you have a circle rate in IPRs given by government, but that's the minimum thing. Above that, you could negotiate and you can do both. So it's both. There is a minimum that the government fixed based on some of the approaches.
sometimes at this,
Yes.
the property becomes actually less paid to circle rate.
Right.
And then you cannot
Then
sell
there is
it
a
with
problem.
something
Then the
below
transaction
5%.
doesn't take place.
Then transaction doesn't take
It
place.
fails. Let's move on to the next
I
one.
have one question.
Yes, yes.
So with the value of the patent today and the N is the remaining life of the patent. But
Right.
generally what happens is in case of a technology or in case of a product, it's not the one patent.
Exactly.
So which patent or how do you find out that key patent for which you have to do it?
may I just add, it will not be Germany, otherwise we don't trust judges, we only trust written law. So it is also in the law, it says there is a maximum amount of royalty which a product can carry in order to remain competitive in the marketplace. And then the general formula is Supreme Court decisions. Let's say you come to the result with one patent, the reasonable royalty would be 10%. Just let's say you find in the marketplace. If you have 2 patents, okay, maybe 20%. If you have 3 patents, still 20%. So it is about that the double of what you pay for one patent protection, protecting a certain innovation, that times 2 is the maximum. So as many patents as come, 1,000, 2,000, 4,000, it can never go higher than twice. And if then more inventions are made, you have this very nice example, then you have to proportion it even more. Then the amount of the whole price, of the whole value per patent goes even lower. And if later on patents expire, that goes up for the remaining ones again. Wonderful libraries full of case law in Germany. I invite you all read the decisions of the German Supreme Court. This has been because of the gift in Second World War we got by that law, where they said we need to get incentives for inventors. So this is why Germany has so many inventors. So whether this will or not, but that is the case. So there's a paragraph says this is the maximum amount which always has to be taken into consideration of royalties a product can get. And then doesn't matter how many patents. IBM had a different rule. IBM had in Germany, at least, I know this definitely, with Steufel, they had, if they had for one invention, let's say 10% royalty for the basis of calculating the innovation. For 2 patents it is twice, for 3 patents 3 and finished. So they have 1, 2, 3. You can triple, in other words, that's what you have for 1 patent, then finished. So many methods, the law doesn't provide for it, but Germany provides for this consideration under that law for employees' invention. This is only an analogy, at least. Employee invention has nothing to do with 2 parties sitting at the table and one tries to pull the other one over the table. I mean, negotiation.
Exactly. Ultimately, it's the negotiation that takes place. But it's a very important question that you asked. If I have 1 patent and there are 100,000 patents others in the product, and my patent goes into 3 other products, how do you calculate the ultimate valuation of it? Ultimately, this is why I like this. You know, because what you're doing is anticipating the importance of your patents in a product, right? So this formula is perhaps the best way to lead you into how much revenues. At the end of the day, ultimately, we look at the revenues of the product, we look at the revenues. We look at the revenue base, what are the bases on your patent, and then we calculate this, right? So again, it's a very complex kind of situation, and as Professor Heinz also supported this thesis that it's ultimately, at the end of the day, we have negotiations that take place, and but negotiations on these parameters, right? Ultimately, they will come, look, this is what the revenue is. So to know this approach is very important for us. Okay, we have other approaches, but they have their own limitations. We use how much this patent or this piece of IPR will earn during its lifetime, and then discount it with it, which is commonly done by banks and financial institutions. All right, this was about the valuation part. I'll be very quick. Next, I will talk about royalties. Next slide. Oh, I'll talk about taxes. All right. So let's go to this taxes part. All right. So I think this line is very important. The only thing certain about this life is debt and taxes. So everybody has to pay taxes. Whether it's direct tax, indirect tax, and IPR is one of the most complicated piece of transaction, as we've seen just now. If you can't value it, how do you tax it? And the taxman that in India we have is always, after you, this transaction. I mean, I can do it. An engineer, a team of engineers working here, working on supporting some software development in US, and they are doing it internally. How do you value their piece of contribution? Infosys has 100,000 of employees sitting there working for third party, or they are working internally for their own team. How do you value their contribution? So if you don't know the valuation of a software, or the software is nothing but a copyright, how does the taxman behave? And some examples I'll show you. The taxman behaves in the worst manner. He will say this is what the transaction is, and you have to pay this much as a tax. Okay, income, but basically, so there are all these kind of taxes when you do an IPR transaction, which are common in a real, say if you're selling your car, probably all of these will come, all of these kind of taxes will come, which is your income tax, your TDS, your capital gains, your GST, and of course the states, to make it more complicated, state stamp duty. So in Mumbai it will be different, and in West Bengal it is going to be different. Alright, so we quickly touch upon, these are the types of taxes. Royalty, this one, royalty transactions. So basically, the Income Tax Act defined, though I'm defining royalty based on our Indian Income Tax Act 1961. When you do an IPR transaction, and it could be anything which is the transfer of any rights completely, imparting model, design, importing information, the transfer of all the rights, or even granting part of it. Okay, so it covers movies, songs, outsourcing companies. It covers your cloud-based licenses which you do, right? Software that you install on premise, software that you install on cloud. So all these are called royalty. In our colloquial, when we talk day to day, we may mean royalty something else, royalty from a book that I got. But from Income Tax Act 1961, royalty means all these kind of transactions, which is everything actually. Alright, even if you're sponsoring an event, that may be based on a royalty, or that may be based on a commission. So coming to whenever you transfer your rights, or you provide some information concerning imparting information. So as I said, Infosys team of 4 or 5 people supporting a call center. How do they bill? Okay, they're not creating IPRs, but what they are doing is in a call center they are imparting some information. So from taxman perspective, this is all royalty, and then he will tax them on the parameters that I just said. It includes GST, it includes income tax, capital gains, everything. So this is how the complex situation is. I don't know if anyone has seen an invoice when you license software. Okay, it's such a complicated invoice. I have seen it many times. So it has all the components which we mentioned, and if the government feels no, this transaction is nothing happened of this sort, how do you prove that you have given this software to somebody in USA? The taxman will say, oh, its value is so much. No, and you will say, come on, I just got my salary. That's it. I'm happy with it. Ultimately, I got my salary. 1 lakh rupees or 2 lakh rupees, I got my salary. So the taxman will say, no, this 2 lakh is your salary, but what is the value that you exported? Okay, so there is always going to be a dispute in IPRs because it is intangible, there's nothing set in the market, and all kind of taxes would come into play during an IPR transaction. And as I said, IPR transaction is very wide. As per the taxman, this is what will be taxed. Any of such transaction you can think will be taxed. Let's move on. Next one.
Sir, it will be very good if you really give an example like the Infosys, who is sending the codes over mail or something using internet. So basically he is transferring copyrights, and now from the taxman perspective, actually he is getting his own salary, what you are saying.
Exactly.
So are there real cases existing where they have to pay on the valuation? So how?
So that's what the transfer pricing slide will come. I'll answer that perhaps in next few slides. It's a very good example. I mean, Infosys, where lakhs of 100,000 engineers working on a copyright and giving it, and taxman says, look,
and that tax will come to Infosys or to that engineer fellow who is...
No. It comes to Infosys, of course, because money goes to Infosys, and we don't know where it goes. Does it go to India or it goes to US entity? What is the double taxation treaty to make it more complex situation? Anyway, we'll come to that part, but let's understand that was a very complex slide where of Income Tax Act 1961 giving you royalty. But if you look at in IPRs, from IPRs perspective, there are two kind of transaction. One is of course a license, giving license to your copyrights or your patent. The IPR owner in India gets a revenue, right? It will be like his income. Suppose I am doing a license, I have a code with me which is based on suppose AI module, and I give it as a license. I say, okay, give me 2,500 rupees per month, because I know this price because I just paid this 2,500 for an AI module to Google per month. So, so the Google gets that income. It's normal income that it gets, but I deduct a TDS on that, and as a user, I get it as a business expense. So when I give 2,500 rupees to Google for the AI module, I will say, okay, this is my business expense. Okay, but what will happen? I also pay GST on it, goods and services tax on it. All right. So this is a very simple transaction, but it involves income tax, it involves GST, it involves TDS, and it involves business expense that needs to happen. Okay, this is normal. It's like renting your house. License is nothing but renting your house, as an example. Then comes the sale transaction. Suppose I want to give completely my code, all the rights in IPRs. We call it assignment. In IPRs, it's called an assignment in India. So the IPR owner, he pays a capital gain based on the sale price. Suppose I sell my whole software for 100,000 rupees, whereas I acquired it. Say 5 years back, I paid like 10,000 rupees, or my income was 10. So there is a capital gain tax that I have to pay on that 90,000 rupees. Alright, it's not my income tax, by the way. Same thing happens in the real estate also. When I sell my house, I have to pay capital gain tax on it. Okay, and capital gain tax is different from income tax, because in capital gains, you have certain liberties, much more liberties. You can pay it over the years, and we'll come to the depreciation part of it. This is my capital gain tax, and I pay to the government. But what happens to the buyer? Buyer acquires that piece of software. In the first year, he cannot put it as a business expense. But over 6 years, it's like depreciation, right? When you get a car, you get a depreciation allowance. I know I'm speaking to engineers here, but this is very common accounting terms, where you get over 5 to 6 years, you get a depreciation. Same thing with IPR. So if I buy an IPR piece of IPR get assigned to me, I buy it, say for 100,000. Each year, I would get 15,000 or 20,000 as a business expense allowance for that. Okay, this is as per section.
Here. So it's irrespective whether I am getting through assignment, patent or software or anything.
Yes, absolutely.
So IPR is a generic term.
Generic term, and it includes the definition is given royalty. The tax officer will say is the royalty. Okay,
He is not bothered if it's patent, copyright, design.
No,
nothing.
he is not bothered. He does not distinguish.
Good that he is not bothering that. Otherwise it will become more complicated.
Right. And sir, it does become complicated because many of these transactions are done within organizations. So Infosys here would transfer the code to Infosys US.
Okay.
Then how would you value that? Or how would you pay capital gain on it? It's within the company happening.
So it's only on book which is being.
Yes, exactly. And if it goes to a tax haven, as he was mentioning earlier, it goes to Mauritius, or it goes to countries where there's UAE, Dubai. Dubai has just introduced some taxes, but earlier there was no tax, and tax is very marginal. So it goes to these tax havens, as they call it. Indian taxman loses its amount, and then it's such a vague thing. They say, okay, you got the salary, but at the end, this is not. The valuation of your IPR has to be done at that stage. And the taxman has no expertise to do it. has finally.
Good that he has not expertise.
Right.
That is double-edged sword.
So, yeah,
Sir, like
lot of complicated things happen.
Sir, like
As I
in-
said, we just filed an appeal, the last week only at IPAT on, maybe the next slide will explain that.
Sir,
Yeah.
just one query. The state, when the capital gains, if you reinvest within some time period,
No,
so here
no,
that
I was thinking nobody asked me that question. I was just thinking, no, there's no. If you so in a real estate in India, if then you get capital gain after as a seller, I get that money. But if you again buy a property, so there is an exemption on it, which says that okay, you don't pay capital gain because you have reinvested within 1 year. But that's not the case with IPRs. No, it's
And in this statement, this figure is mentioned as royalty only and not as income from other sources. So
no royalty. Yeah,
it is royalty is a term which is there.
Yeah, 35 section.
Yeah, there is, but one should also mention here, just as a supplement, the German taxman, for example, or US or whatever, he is not really interested in what you make an agreement with the person in Red Cayman who buys your IP. He says, forget about this. I wish the arm's length transfer price to be taxed by me. And there's an OECD rule, country by country, what the appropriate transfer price should be. And if you deviate too much from the recommendation of the OECD in Paris, tough luck. You will have maybe made a nice agreement, you get only 500 euro for this patent, and the taxman will say, no, the real value is 50,000, I'm sorry about this, and I wish to have the income tax where you paid or corporate based on that price, not on real.
Absolutely, and this is exactly my next slide we'll talk about. It's good that we got that clarified, and I will just give an example of one of my clients without naming the client, but I can tell you through example what the problem is. This is we talked about this transfer pricing is an accounting practice. As you said, if you do a transaction, if a subsidiary in India, say Infosys India, gives some code, some IPR, or even some, I'll give you an example. Anything, IT-enabled services, support services, software development services, these are all royalties, okay? Technical fees services, management fees, royalty fees, corporate guarantee fees, loan receivable rate. So this is if the transaction is taking place within the entities, okay? Then the question of Infosys India will the Infosys USA will pay to Infosys India only the salary of people, but how much? So if a developer here is earning 50,000 a month, he gets 50,000 rupees a month, that's it, okay? But through that software, which is being sold everywhere in USA, maybe it's not software, but an IT-enabled service, the Infosys USA's make billing much more. Do you understand now? Okay? So here in India, we are losing revenue. We are only paying the employees 50,000 rupees, where it may be $50,000 there. That particular piece of information or IT-enabled services that Infosys USA.
Can I ask this question?
Yes.
It is very interesting.
Correct.
Now, when you say IT-enabled services,
Everything. Yeah.
this covers everything?
Everything. So the example I was giving, so the subsidiary here used to provide news to its third-party clients, okay? But they used to be channeled through the US entity. So the taxman said, look, you could have directly given to the third client, but why are you giving it to the US, the main office, and then it is being circulated among them, work is being done here. So you show me the bills, revenue that your clients in US have earned. This is what, and we have appealed that. I don't know the answer, let's see what the appeal says.
Know-how is also
Right.
included
Right.
in IPR?
Yes, absolutely. And you may call it trade secret. This is a know-how. I give you a know-how. In India, we don't have a statute, as Dr. Naki mentioned. So when I give you a know-how, I will make a contract. Okay, if you violate my know-how or a trade secret, you have to pay so much damages to me. So this is also part of transactions, and these transactions are much IPR transactions or royalty based transactions are much more
Yeah.
in India than anywhere. It's not we don't do manufacturing in India at all. What we do is this transaction. So the taxman is getting mad at us.
Maybe I can, it is all of course fully, he does it so well.
Very
But one recommendation, what we do with German other subsidiaries, let's say of a US company in Germany, or of a Taiwanese one, or maybe a China one, then they make an invention there in Germany, German branch. Then you need an opinion, you need a credible opinion that the value is very low before you give it to a cross-border to the United States, to the mother company or so. And that you do best, the invention is there, and you do not do any patentability search, feasibility search, nothing. The invention is in a very raw state, and then you make a master agreement even with the mother company in the United States, where you say, you get each and every invention proposal we get from our employees at 5,000, let's say, US dollar. That's it, because the whole risk, whether later on it is valuable, you must do this, you must search, you must obtain patents, everything, 5,000 per piece. Then the German taxman, if that was a well-reputed patent attorney or a firm which is accepted by financial authorities, will say, okay, that's it, that was the transfer price. So early, low value, and then the invention goes over the border, and then it matures, it becomes wonderful, it is later on of a high value, exactly your example, they now go and license it out. And then you can try to say, yeah, that was only detected later, but the taxman will go after you. He tries, of course, to prove that you knew before that it would be valuable. There's a dispute. It makes all lawyers of this world richer. I would say not rich, they are all not rich, but it makes them to have a good income out of this dispute with authorities, particularly tax authorities.
Yes, absolutely. Okay, yeah, I like it because it becomes more complicated now. Okay, next, I think we are done. Yeah, so these are, next slide please. Yeah. So again, these are some of the challenges in the transfer pricing. When you give a code or a piece of IPR or a know-how or a source code, when you develop a website, even developing a website for some outside person, this is what they do, determining the appropriate price, transfer price, okay? They will not say, okay, you paid salary 50,000 to a developer here. They will say, what is the value of IPR that you are giving it outside to your, either to a third party or to your own company, okay? So, as you mentioned, there has to be an arm length principle. You have to assume that it is a third party you are giving your code to. You are not giving it to your parent company. Even if you are subsidiary, you are giving it to your parent company. There is something called arm's length, which is second, ensuring that the transfer price is, you have to presume it's a market price. And how do you value? And that has already been told to you. How do you value? Taxman has its own ways of valuing it. It will say, I am not assuming that you are giving it to your parent company this code. I am presuming. So all the developers of Microsoft in Hyderabad, right? They are developing new products, right? Azure and Windows and everything coming from there. They get their salary, right? But the taxman, and there is a big appeal already pending. Taxman says, no, what is the value of Windows that has been licensed globally? Okay? What is the value piece of that code? What is the sale on that piece of code?
So,
maybe
what
that
is
is
the
what we
Indian tax authorities want to tax what has been produced in India.
Correct.
So they are
Exactly.
saying if,
Which is fair enough.
which is fair, that if the employees in India have created something which is sold in the world at that price, so they want their share on it, tax on it.
Yes, that's the simple thing.
They
So
want
Mountain
GST
View,
on it.
Microsoft in Mountain View, Seattle, there they say it's not your parent company. You presume it's at the arm's length principle, that you are selling it to a seller directly. So the tax manager will come and say, no, value this piece of patent or IPR or copyright at the price that has been sold. It's not given to Microsoft Seattle there. Alright? So,
Sir, how the taxman handles a case where
they just put it maximum.
You see,
Yeah.
it's a good thing that they don't know much complexity.
good, but ignorance is sometimes on the other side also. No? Then they will ask you something about moon. So coming back to my question, sir.
See, that is probably one of the reasons that these big companies, have their offices in tax havens like Ireland, Singapore,
Exactly.
or Holland. I understand they also very much.
Red Cayman is very recommendable.
Okay.
Exactly. So that's the reason. Well, now we know.
Now we know.
Sir, my question was, could not complete, that which is being developed here. Like many startups, they are registered in Singapore or in US.
Yeah.
Now their IPR gets patented there. So it becomes, IPR say in Singapore or in the US. So how that is valued, how taxman handles that? Because the property itself is of that place. It's no more of this place.
Yeah. So the revenue will come to Singapore and US, wherever it comes. So taxman know there are columns. If you fill up a income tax form, you will have to declare that income. Okay, and the taxman will say, here you are paying 50,000 rupees to a developer, and there you are earning in dollars all that income. Please show me
No,
what
but
is the contribution of your company's Singapore office. What is the value addition being done there?
No, but whether the tax will, these laws, Indian laws will apply to that. That is what my
No,
question.
Indian laws is they are going to tax Indian entity only. Okay, but they are going to tax it at revenue that the Indian entity earned globally. They are not going to. They are not going to tax based on just the salary which Singapore office gives you.
But it doesn't matter whether the patent has been, it's a Singapore patent or US patent.
But
It's
it-
owned by the
Indians.
Indian entity.
Right.
The Indian entity has to pay a tax.
Right.
The
Exactly.
decisive thing is.
No, but
was
this is
the
not
idea
Indian
for
entity
that
because
that
company
in
itself is
India,
registered there.
Under Indian
So-
law
so
or in
parents-
Singapore. If there's also an ideally transfer to Singapore and then somebody files a patent application, you have transferred the trade secret know-how whatsoever out of India, and if it would be Germany, the German taxman would say, this, I wish to have the transfer price tax on that. That the idea was created in Germany. So you must make sure that your inventor was on the moon or somewhere outside at least of the reach of the German taxman. Then it is okay, yeah? Or lived since 50 years in Singapore already underwater or something like this. As long as it was sinking in India, you have to pay.
But is it not that the case, like whosoever owns that patent, if that is a US patent or Singapore or German patent, if it is owned by an Indian entity, then the tax on that patent has to be paid by the Indian entity. Is it the case?
That's what the taxman will perhaps say. But that's not correct. That's not correct. There is a value addition that is happening outside India also,
Exactly.
right? So US people may be marketing much more on that. So the taxman will say, it can become complicated, right?
This is what I meant by maturing the product. You
Right.
really cheaply out in a raw state, only the idea, low value, low transfer price tax, then it was out and then it is developed. All this is what is created outside the case of Germany, and that has nothing to do with the German taxman. This is fantasy. But you will have to fight disputes. I said, lawyers wish to live and
But Sir, my question was little more than that, that the entity itself is, say, a startup which is registered in Singapore, having some developers in India. So the entity is also registered in Singapore, and IPR is also getting patented there. So in that case, what will happen? It is
the
owned by
IPR got
entity.
originated in India. It got transferred. I don't know whether it got transferred or not. But fact is, Singapore entity is billing it across, right? Ultimately, the money is coming into Singapore entity, right? Is that correct? So what you are doing, paying to the Indian developer is only 50,000 rupees, whereas your Singapore entity is earning, and you have to declare that in the form. If you are a group company with office, one of the offices in India, you have to declare your revenues from Singapore office. Once you declare it, they will say, look, this is coming from the work that has been done in India.
Yeah.
You will say, no, Singapore entity did this value addition there. So this much money goes to them. They did marketing. So this is where the dispute, the last point would come, risk and dispute with tax authorities. And this is where Professor Hines just mentioned, this is how lawyers would make money on your IPRs. So that's my last slide, and this is about taxation.
Wonderful.
Thank you.